Hello and welcome to this Health Plus Law webinar. My name's Dion Kagan and I'm a Research Associate at the Faculty of Law and Justice at the University of New South Wales, where I contribute to projects about the legal experiences of people living with HIV and hepatitis B. This is the second of two webinars discussing new research about the legal environment around bloodborne viruses in Australia. In the first part, we looked at HIV-related case law in Australia, and in this webinar, we're talking about hepatitis B and the law. This is quite uncharted terrain among researchers, despite the fact that hepatitis B is the most prevalent bloodborne virus in Australia, with an estimated over 200,000 people living with chronic infection. But before we delve into this terrain in more detail, let me introduce you to my colleague, Dr. David Carter. Hello, David.
Hi, Dion. Good morning.
David is the Scientia Associate Professor at the Faculty of Law and Justice at UNSW, and he's the research lead here at Health Plus Law. He's also the lead author of this report that we're going to discuss now, which is called Hepatitis B and the Law, a mapping review of contemporary case law. David, in the previous webinar, we talked about the concept of an enabling legal environment and touched a little on how important that concept has been in the HIV world. This is kind of a less explored area in the response to hepatitis B, and importantly, in the everyday legal experiences of people living with hepatitis B. That's also a sort of far less examined space. And I was
Mm.
just wondering, before we get into talking about this review, why do you think the legal environment around hepatitis B has been overlooked somewhat by researchers and health policy makers and others?
Mm. Uh, Look, that's a fantastic question for which I don't really have, I think, a clear answer. I have some hypotheses, I suppose. I think it's overlooked by comparison, say, to HIV and to hepatitis C. Probably the thing that marks out the HIV response and hepatitis C response is that there are now quite long-standing, well-organized communities that form in and around these two bloodborne viruses. A number of communities, both people who are living with or affected by the bloodborne virus, but also other communities who are affected by it. So I would think here, for example, people who use drugs and hepatitis C, a long-standing connection between those two, indeed for HIV too. Sex workers and people who work in the sex industry as well across both. Hepatitis B, whilst of course there are people who are living with hepatitis B, in Australia at least hasn't had the kind of community response that we've seen in HIV and hepatitis C. This is changing though, and we're really proud to be able to partner not only with Hepatitis Australia, who's the national peak body here of all of the state and territory hepatitis related community organisations, but in particular Hepatitis B Voices, who has emerged over the last number of years as a really strong, vital, kind of quite active, community-led, community-founded response to hepatitis B. And I think we're seeing, at about time, a community really come together around this condition. One of the things that also I think has happened in terms of why this hasn't been as examined, well, HIV and indeed hepatitis C have been regarded by the law at least as a kind of harm that is worthy of the kind of law's attention. Whereas hepatitis B, legally speaking, has really been in the same category. And so I think those things together are probably why this has occurred.
Mm. Um, that's really interesting, and I think threads of that will get picked up when we talk a bit more about what we found in this review. Because when we went looking for hepatitis B related case law in Australia, we also found that this sort of lacuna was reflected in the case law itself. If you heard the previous webinar, which is the part one, you'll have a sense of some of the approaches or the methods we used to look for cases around HIV in Australia. And we took a really similar approach. looking for legal decisions and judgments in Australia where hepatitis B came up. And the aim of that is to understand more about how hepatitis B figures in the law and what the main legal issues are for people with chronic infection when they go before legal decision makers in official proceedings. So, what did we find in this review of hepatitis B in case law?
Mm. Oh, the long and short of it is not very much. A bit like the kind of the research response to hepatitis B in law, at least generally, where there is really not very much, at least not very much in a sustained way in Australia. Um, in the actual case law too, we found, comparatively speaking, very little. So, to think about it in some context, approximately or at least 200,000 people are estimated to live with hepatitis B in chronic infection in Australia. And so you'd expect, therefore, there to be a reasonably significant number of cases that arise in relation to, or at least mention, hepatitis B, but that's not the case. Uh, in the end, we selected from the kind of universe of cases and decisions, judgments and decisions that we could find, around 40 cases. Now, I'm not saying that there should be more. I'm just surprised that there are so few. But to put that in context, when we looked at, as you referenced earlier, at HIV and the kind of contemporary case law there, for a slightly different time period and things too, but we located and included 280 odd records or cases or judgments there. And this 280, of course, comes off the back of a population of people living with HIV that is much smaller, approximately 30,000 people living with HIV in Australia. So we have here a population, if I remember the numbers correctly, and maths is not my strong suit, but a population that's about 8 times smaller
Mm,
than people living with hepatitis B, producing 7 times the number of records of cases or judgments in the case of HIV, and the reverse, of course, as well. There's probably a lot of reasons for this, and this mapping study is not really the place necessarily to answer exactly why that's the case. HIV and hepatitis B, and indeed hepatitis C, are all bloodborne viruses. So they have that in common, but their histories and their meanings, both in terms of law, in terms of kind of social meanings, in terms even of biological meanings, are quite different, and should be, I think, whilst we often do, of course, think about bloodborne viruses as sort of a whole, they are indeed very different conditions that affect people in different ways, and in fact affect different communities as well. And so, to my mind, speaking from a legal perspective, I think, as I said before, that probably the key difference between, say, hepatitis B and HIV is that, legally speaking at least, HIV has long been, unfortunately, regarded as a kind of harm which the law has taken an interest in, often to criminalise and to punish. Um, this is not the case with hepatitis B, at least at present. Certainly, some areas of law take an interest in hepatitis B, but kind of legally speaking, and indeed, therefore, culturally and otherwise, as flows from that, there is a difference between HIV and its kind of construction as a harmful thing, whereas hepatitis B has not had that same process, which draws, therefore, more legal activity into the frame. So I think they're probably the main differences, I think, legally speaking.
mm,
Um, yeah, I think that's where I'll leave it for this point.
mm,
This is a question that still plagues me a little bit to understand exactly why it's not occurring so much, because there could be lots of reasons. It's not to say that
mm,
people living with hepatitis B aren't necessarily going to court, yeah, but perhaps their hepatitis B is not relevant or not being made relevant by their representatives. We simply don't know.
yeah, and I suppose, one of the ways of answering that is in the other types of research that we're doing in addition to this legal mapping.
Mm,
Um, but it is, yeah, it is interesting that we didn't find any cases in which any transmission related prosecutions related to hepatitis B, which is different, certainly, as you point out, to HIV and hepatitis C. And another kind of curious absence, which kind of is a contrast to the kind of legal mapping that we did around HIV, but also around hepatitis C in the case law, is the lack of engagement with hepatitis B in criminal sentencing.
Mm.
Can you just say a little bit about that and explain that?
Mm. Yeah, look, that to me, as someone who kind of primarily was trained in and researches in criminal law, was very interesting. So, people I think will generally understand that they're in terms of a criminal process, it begins somewhere and ends up with a sentence if someone's found guilty, and those the trial, for example, is quite separate in some ways to the sentencing process. So there's sort of another process that goes on. And in that process, it is well known, and indeed our other mapping review showed this, that HIV is mentioned in those criminal sentencing processes, usually at length, and usually, but not always, as a kind of mitigating factor for sentence. The court essentially is presented with information that they choose what it does with that in some ways, but presented with information about someone's health and a range of other factors when deciding what sentence will be handed down. HIV, depends on the particular circumstances of the sentence, but tends to be a mitigating factor because living with HIV and, for example, having to serve a term of incarceration, these interact in a way that it produces a kind of greater burden on someone with HIV than not, is the long and short of it. Hepatitis B, of course, another bloodborne virus that also does require monitoring and treatment for many people too, just simply doesn't get brought up in the same way, even when it is brought up in criminal sentencing. The treatment is, when it is, it's kind of short in the judgment compared to the very lengthy and detailed treatment given in the context of HIV sentencing remarks. There seems not to be, at least on the surface of these judgments, access to, or perhaps they weren't presented with, information about hepatitis B and how it might affect someone's sentence, life, health, etc. I don't know why that's the case. Again, we'd have to do some more work to understand it, but this is a very stark difference for two bloodborne viruses to have such a clear and well-developed sense of information that kind of gets reproduced in the judgment versus hepatitis B, where at best, really, most of the time is sort of a passing remark that someone is hepatitis B positive, and really not much more is said.
So, one of the reasons why I guess this comparison to HIV is coming up a lot in this conversation is because of this kind of absence, really, and this, the starkness of the difference, I guess, and comparisons aren't always the most useful approach, but in this case, we're kind of leaning into it a little bit to help to illuminate, I suppose, particularly the results of this legal mapping of hepatitis B. One of the things that wasn't an absence was migration law. This is
Mm.
the kind of one of the big areas that of the map, um,
Mm.
so to speak. Let's talk about hepatitis B and migration. This is a big theme, and it's coming up elsewhere in our research work as well. What are some of the things we can say about the legal environment for hepatitis B in migration law?
Yeah, look, this was a big part of the map. I think, as you say, a really significant part of it. Um, I want to say a few things about this because there's some fine points to be made that I think are worth hopefully getting across clearly. It is true that most people living with chronic hepatitis B in Australia were born overseas. Yeah. And so, in some ways, it makes sense that therefore you would see migration related matters in a mapping review of this type. People born overseas, migration related matters are likely to occur. But what I want to at least hypothesize here or sort of draw people's attention to is that there was a very, very significant concentration of migration related matters. Now, at least as we currently conclude it, I think this is a subtle point, but an important one. Um, just because people are born overseas, it does not follow that there will therefore be migration or refugee related matters appearing in front of judges and tribunal members. Um, uh, Rather, the specific legal and regulatory settings of Australia's migration system generates those matters. Yeah. So, whilst of course, in some way it makes sense that we have a population of people living with hepatitis B, the majority of whom are born overseas, you would see some migration matters. That follows. But the fact that they end up in disputes or having to fight back injustice or have a departmental decision revisited by a tribunal and other things. That doesn't follow from the fact that they're born overseas. Rather, it follows that the Australian legal system regards hepatitis B as something of relevance to the state's control of migration and of people crossing borders. Um, you know, our research and our discussion around this has been now quite lengthy with health plus law, and particularly with Dr. Anthea Vogel, our colleague, whose area of expertise this sits in. But essentially, for those who don't know, and I'll give the brief story anyway, that Australian migration law regards hepatitis B as something relevant because it regards not just hepatitis B, but actually more specifically the actual seeking of care and treatment. So taking care of your hepatitis B as a risk, quote unquote, to Australia's health and community services. And so therefore on that basis can deny people entry state or residence. So to be clear, it's not that Australian migration law thinks, oh, there's a communicable disease and so we have a kind of public health concern around that. That's not the case. Rather, it's the fact that by taking care of it, you could, take up resources. That's a really interesting way of structuring things. So the problem isn't that you're hepatitis B positive. The problem is that you're taking care of it by seeking appropriate medical treatment. There have, of course, been significant changes over time in relation to migration criteria that applies to hepatitis B, and they do have a pretty big impact over time. And so some of the case law that we picked up over time included some older cases that related to slightly different law, but still there was a kind of a preponderance of them, and we could draw some conclusions across time.
Another related sort of area of migration law, and forgive my legal ignorance, is refugee law. Of course, refugees aren't migrants, they're something else. But I understand that refugees are making a humanitarian claim, and that sometimes these become, these claims end up in front of decision makers and judges when there have been complications or rejections of visas and such. Refugee law came up in our findings around hepatitis B and the law, and so I'm wondering if you know having hepatitis B, living with hepatitis B, can inform a humanitarian claim in the same way that other chronic conditions or disability or other sort of identity markers are sometimes used as part of claims for refugee status.
Yeah, thanks, Dale. And you're right, it's worth spending a little time thinking about this particular question. I don't profess to be an expert in these matters, and so what I'm going to say is quite high level. But I think I can speak to what we found at least in the mapping study. So yes, as opposed to migration matters, yes, protection matters also appear in this mapping study, most definitely. A question which came up in a few of the earlier cases, and indeed I think is an area of change that we think is possibly about to change through reinterpretation of the law, but at least in our mapping study, there were some very important cases where community members had made a variety of claims, including that a person living with hepatitis B, on other grounds too, but a person living with hepatitis B was deserving of humanitarian protection. This came down to a particular legal question, which is about whether or not someone living with hepatitis B and migrating from a particular country, sorry, seeking asylum from a particular country, should or could be classified as a member of a particular social group as part of that process. I won't get into the weeds on what that means, but I'll say that that question is part of an important series of tests that are used to define whether or not someone is a refugee. Uh, some of the things that were really spoken about in that particular decision were the nature of hepatitis B, the nature of its treatment and experience in that person's home country, the attitudes and social kind of attitudes, particularly of people in that context regarding people living with hepatitis B. You know, if someone is found in this case to belong to a particular social group because of their hepatitis B, their hepatitis B might become relevant for their claim for protection. And so we looked at a couple of cases in particular, which people can read about in more detail in the report. The thing that stuck out for me particularly was this question, not only of the particular social group, but also the kind of practical, everyday reality of seeking appropriate monitoring and treatment for hepatitis B in an applicant's country of origin. And one of the judgments certainly dealt at length with that question. Again, it was some time ago. Of course, things change in Australia as they do in other places too. But what was very interesting was this question of if someone could be denied health services, not just hepatitis B services, would that be discrimination? Would they face difficulty in accessing medical facilities because of the health system and structure and other social structures within someone's own country? From memory, there was less than half a dozen judgments that we included that really related to hepatitis B. Of course, other judgments and decisions mention it, but we felt these ones really dealt with it in a pretty material way. And so, you know, I'm highlighting some of the kind of things that were discussed in these, some of the issues that were raised, rather than kind of coming to some, you know, firm conclusions about it. I suppose what we want to say, number one, is that hepatitis B is definitely a feature of migration-related matters. It's definitely a feature of refugee and asylum-related matters. And there's a range of outcomes over time that shift and change about some pretty technical and important legal questions that we see, at least in this case law. I think the other thing that certainly our colleague Anthea Vogel could speak more to this was that, at least in all the cases that we did end up including and analysing, people living with hepatitis B were also making claims for protection or other related claims on the grounds of other matters, so homosexuality, ethnicity, religion, political views and unrest and other things too. And so, in a way, we see here something that we know well in the kind of health social sciences, indeed health, and of course, people with lived experience understand very well that someone's hepatitis B is not just a thing on its own, it's rather experienced intersectionally and with other contexts, all brought in together.
Yeah. Yeah, and that does, I guess, kind of remind me of, you know, some of the limitations of this kind of mapping that you referred to before, which is that it only gives us a partial picture of the experience of the people involved in the cases. But, you know, that said, these refugee-related cases that you're just have been describing are really interesting, and I would direct anyone who is interested in the detail of those cases to our report itself, because we discuss them in more detail there. Just before we wrap up, David, you know, there's other findings that we could talk about, but I wanted to just get you to reflect on some of the implications of this report. Why do these findings about case law matter?
Yeah, look, number one, this is really a world first in terms of mapping the case law anywhere in relation to hepatitis B. And so, like all firsts, it's very exciting, but also kind of raises so many questions. We kind of know there's something there. We don't quite know the detail, and more work has to be done. But even from this early mapping, to me, I think there's a number of things, and we note some of these in the report. But the one that sticks out for me when I'm being very practically minded about the law and a lived experience of the law for people living with hepatitis B, is that the vast majority of cases, it seems, are ones in which the state acts as either a party or a prosecutor. So compared to private law matters where you or I might take each other to court, this is where a person living with hepatitis B and the state up against each other in those contexts. This means, at a very practical level, that change to make things possibly better, we hope, for people living with hepatitis B, can be made with changes to state practice, and particularly in relation to some of the areas of law that we describe. This isn't a matter of having to sort of shift any number of parties and their behaviour, but rather the state plays a really significant role and potentially a side of intervention for improving a legal environment around hepatitis B. I think that's probably the thing that really sticks out to me most, and is also a lovely thing that even in this first kind of look at these matters, we can identify at least, well, there's actually a point of intervention here, and that might be around the state's own practice, both in choosing to prosecute or bring matters, but also in controlling the kind of matters that clearly are causing these disputes to emerge. The other thing I think that sticks out as well for me is this question we've spoke about earlier, which was like, why does hepatitis B only emerge in so few cases, at least that we can access in the public record? And again, that's a matter of comparison compared to what we sort of, in a sense, would expect to see given the experience of HIV and hepatitis C. And I would encourage people watching this to have a look at our other report and our other webinar, but also to see the work of Kate Sear and indeed your work, Dion, in relation to hepatitis C and its appearance in both legislative and court and tribunal contexts as well. Again, we're hypothesizing a little bit about why this might be the case. I think a lot of it would have to do with the specifics of hepatitis B and how it emerges in people's lives. And also the lives in which it manifests. We know that most people living with hepatitis B were born overseas. And so, from our interviews, certainly with community members and speaking with peers and their organisations, it's clear that there is a very different kind of consciousness that's formed around the law between people living with hepatitis B and those living with HIV. Partially, I think that's to do with people having migrated to Australia versus perhaps more people having been born in Australia living with with HIV. But essentially, this idea that for someone living with hepatitis B, there seems not to be a willingness, at least, or perhaps even hasn't yet occurred to them that certain of their experiences that happen to them during life are legal matters and are worthy of kind of fight rather than withdrawal. And so I think there's something there as well that is worthy of some further discussion. As a final note, I think this kind of question of migration and asylum are very important. And the law as it currently stands is a barrier and an obstacle for people living with hepatitis B to seek and successfully migrate or to claim asylum in some cases. There has been some very significant and important law reform recently, which means that for the vast majority of people living with hepatitis B, the earlier situation whereby their healthcare costs would be a kind of barrier, or at least a very long and stressful process to get through this kind of significant cost threshold question, is now no longer quite as active. But of course, there still are kind of after effects of that for many people, and still a lot of fear around that. And of course, these are changes made by policy, and so they could be, of course, changed at any time again. So I think that's something that I want to really highlight and also remind people that this policy and law reform change has occurred. It should make it easier for people living with hepatitis B. So I wonder if we do this mapping study again in 5 or 10 years, do we see a drop-off in migration-related tribunal decisions? Perhaps because of that, would be a good thing to see, I think. But that's something I would want to leave with.
Thank you so much for walking us through that, David. I think, this report really highlights that there's more work to be done in the space around hepatitis B in the law. And, it shows us a lot of things, but it also raises questions, but they're useful questions because they maybe help guide us or kind of offer clues in a way to the particularity of the legal environment and the way that it's a particular sort of legal environment that we need to use other methods, other modes of inquiry to find out about, including talking to people who are affected. And that's a big part of our project that is underway.
Mm.
Um, in interviews and in our national survey, which we will be reporting results from soon. So thank you so much, David, for taking the time to walk us through the results of this legal mapping review.
No, thank you, Dion. Thanks for hosting. And can I also, in particular, thank Cara Bruce for putting together this recording and webinar so ably, and indeed colleagues as well, who are co-authors and members of the Health Plus Law team. So Anthea Vogel, who I've mentioned, of course, Rhys Evans, James Brown, and Hamish Robertson, and indeed you, Dion, as well, who wrote and researched this piece of work with us. And also to thank, of course, the Australian Government, Department of Health and Aged Care, who we receive grateful support and funding from for Health Plus Law under the BBV and STI Research and Data Program.
So if you want to read more from hepatitis B and the law in Australia, please go to our website, which is healthpluslaw.org. You can find this mapping review. You can find our mapping review of HIV in the law. You can find a series of other publications and outputs. And if you want to hear about our work and future webinars, please do sign up to our newsletter, which is also on our website. Thank you again, David, and thanks to everyone for tuning in.